this is great news. So the second good news, the Department of Homeland Security extended flexibility for responding to certain agency requests. I am now talking about requests for evidence that some of the applicants receive, requests to continue, so-called notices of continuance, Form N14. I know that people going through naturalization process through the adjudication of their Form N400 sometimes receive notices of continuance. Those notices also include notices of intent to deny, intent to revoke, and a couple of more notices. So if you guys are receiving those notices and you have received them between March 1st, 2020 and March 26th of 2022, and there is a certain deadline indicated in this notice, just keep in mind that you're allowed 60 additional days to respond to this request for evidence, for example. So that's really good news. Requests for evidence, of course, we don't want to sit on them for too long because they are associated with some immigration benefit. So we try to respond to them as soon as possible. But sometimes those are tough, and sometimes they require some additional documents that take time to obtain. Sometimes those are the documents from other countries or documents that need to be translated. So for some people, of course, it makes sense to use this extension. But if you can respond without using this extension, it's always better. So we always try to do that. So that's great news. What also happened? Oh, travel ban. So we thought we said bye to travel bans last year, but since Omicron COVID-19 variant was discovered in South Africa, a new travel ban was introduced by the President Biden's administration, and it was concerning 8 African countries. So people who were residing in those countries could not come to the United States. So, of course, there were certain rules described in this proclamation. It was a proclamation banning travel from those 8 African countries, such as Zimbabwe, South Africa was on the list. So, yeah, starting December 31st, this ban has been gone. We don't have it now. So this is great news. I know that it affected a lot of people, and now it's all gone. So great. Very happy about that. No travel bans. Of course, vaccination requirement and the testing requirements stay in place. I like this science-based approach way more than the approach based on the countries of residence for certain people. So it's, to me personally, it's much more way thought through approach when we use vaccination records and when we test people coming to the United States. Okay, the next good piece of news has come from the Department of State. So the Department of State has authorized its consular officers to waive interview requirements for certain work visa applicants who are applying for work visas. And I will talk more about the certain kinds of work visas from outside of the United States, in the country of residence, or the country of nationality. So the visas that I talk about include H1, H3, L visas, O visas, P visas, cultural program Q visas, H4 visas. I think I mentioned those. There are, of course, certain requirements. So not every applicant will be having this opportunity to actually waive the interview. So the applicant must be applying for a visa in her or his country of nationality of residence, as I mentioned previously. An applicant must have been granted visa, any kind of visa in the past. If an applicant is coming from a country that has a visa waiver program, then such applicant must have previously traveled to the United States based on ESTA authorization. So why this requirement is here is because the Department of State wants to make sure that there is a record of this non-immigrant at the Department of State, at the consulate, that some of information has been previously disclosed, that this is not a new applicant. This is someone who has been approved for a visa in the past. So this is, of course, great news, and I hope that some of our clients will be waived, will not have to appear for an interview. I know it's stressful. It can be stressful. No matter how people prepare, that there is a stress factor associated with the interview appearance. So it's great that these officers were allowed to waive the in-person interview requirement. So another requirement to the applicants is that they must have never been refused a visa previously, unless such refusal was overcome or waived, and the applicant has no apparent ineligibility or potential ineligibility for this kind of a work visa. So why do people get refused visas? There are multiple grounds based on which people can be refused visas. This whole process is discretionary. It's also, of course, based on the legal provisions. Some inadmissibility grounds may be applicable to such people. So if that's the case, people will need to waive those inadmissibility grounds. But anyways, just to get back to this great piece of news, just very excited about the Department of State finally trying to work with the backlogs of applications and petitions pending at the consulates and the embassies. And hopefully the whole process will go smoother, faster, and more efficiently. So yay! It's great that our Department of State recognizes how backlogged the consulates and how much work it creates to interview people in person. It's time consuming, it consumes the resources that are limited at the Department of State. So this is really good news. I see that some questions are coming in. Let's see. I will definitely answer all the questions that I receive right after I talk about all the news. Okay, let me see. Another good news is that the Supreme Court will review, or the Supreme Court of the United States was asked to review a so-called Remain in Mexico policy that has been in effect since the Trump administration. So this is a policy that was introduced by the President Trump's administration back in the days that affected mostly Spanish-speaking asylum seekers at the southern US-Mexican border. So those people who came from mostly Spanish-speaking countries to the border and asked for asylum in the United States had to remain in Mexico while their immigration court proceedings were pending, or until a certain point in the proceedings. So this policy affected a lot of Spanish-speaking people, mostly, who had to go back to Mexico, remain in Mexico during this whole time. Of course, some of them have children, spouses, some of them have medical conditions. So by remaining in Mexico, the U.S. was keeping those people in Mexico. The U.S. was trying to reduce the number of asylum seekers. So that was President Trump's plan. This policy was reintroduced by the Biden administration. And so now finally the Supreme Court was asked to review this policy. So finally we can get a firm answer as to whether this policy is legit. And the Supreme Court was asked to review the Fifth Circuit Court decision that agreed with the Texas judge's ruling regarding this policy, that this policy has to stay in place. Meanwhile, Mexico reported that the number of asylum applicants in Mexico increased by 2 times. So there are a lot more people who actually decided to apply for asylum in Mexico. Probably there are some people who've been waiting for the United States officials to process their applications and then just decided to apply for asylum in Mexico. So hope it works for those people. Another piece of news is that the USCIS, unfortunately, has been denying the humanitarian parole applications that were filed by Afghani nationals. So just to give you an idea of how this whole thing worked. So we all are aware of the crisis that has been going on in Afghanistan. A lot of people who were in Afghanistan applied for a humanitarian parole. So this is a document that would allow them to have their cases processed and for them to be allowed to enter the United States based on the humanitarian reasons. So our firm filed multiple humanitarian parole applications, and we've been waiting for the decisions. We've been updating the USCIS as to the address, change of location of those beneficiaries, because once they are out of Afghanistan, their cases can be actually expedited. So their humanitarian parole applications can be expedited even more. So that's in the interest of the humanitarian parole beneficiaries to get out of Afghanistan. And I know it's hard and not a lot of people can do that, but I had 2 clients who were able to move to another country, and hopefully their applications will be adjudicated and not denied. So the USCIS has been denying those humanitarian parole applications for those people who remain in Afghanistan, just because the embassy is closed there. There are no consulates open there. And that's the whole reason, one of the reasons for denying those applications. Probably many of you heard about the Build Back Better Act that was introduced and was actually passed in the House of Representatives, and then it went to Senate for consideration. So all of us were excited after the November news. This bill is a great bill. It's not ideal. It doesn't give a path to citizenship or lawful permanent residency status in the United States, but it does allow a 5-year work authorization for undocumented immigrants within the United States, those who have been here even before January 2011. So those people, according to this Plan C of the bill, they have the right to apply for the work authorization, and they also have the right to extend this work authorization for a period of 10 years. There was another provision that was giving parole documents to those people. So basically a travel authorization to travel internationally. So there was also an option to recapture about 400 unused green cards and provide exemption on the numerical limitations on visas. So all of this is to basically reduce the backlogs that are existing due to the pandemic. This bill also was to provide almost $3 billion in funding to the USCIS to increase its capacity, to reduce the backlog once again. So it was a great bill. The great part of the bill, Part C, Plan C of the bill, was specifically about those immigration provisions. And it looks like, so in December, on December 16th, the Senate parliamentarian issued its advisory opinion that unfortunately means that this part of the bill would not likely to survive the process in the Senate, but the Democrats remain hopeful that this immigration plan will anyways go through. Some Democrats said that they are willing to reintroduce the bill. If it goes through, if it becomes the law, it will be a major accomplishment in the field of immigration law. And it will be a historic moment in the US immigration history. It will give protections from deportation to almost 7 million undocumented immigrants within the United States. And those people will be able to travel, to work, to contribute to the US economy by working officially, filing taxes. So good news that Democrats are not giving up, and they actually are willing to pursue their agenda and explore different avenues that may be still available to get these immigration provisions through. So these are the news that we have here regarding the DHS and the Department of Homeland Security. So Department of Homeland Security and the Department of State. And I want to cover a couple of questions that we received. All right, so first question. What would you recommend when Congress has not come back regarding an I-130 expedition? So this is, as I understand, concerns a congressional assistant request to expedite the review of a currently pending I-130 petition. Okay, I would first of all reach out to the congressional office just to see if they received the request, if the form that you submitted is the correct form, because forms differ from office to office. Just make sure that the correct form was submitted and that it's under review. There is another option to contact the USCIS Ombudsman's office that assists with resolving case processing problems with the USCIS. A request can be submitted online on the USCIS website, via email, or you can even mail the request. I usually do it electronically as it saves time. Okay, so another option, when you have a petition or an application that has been pending for an extensive period of time, there is an option to talk about a mandamus action. It's a federal court lawsuit against the Department of Homeland Security and several other parties involved in the case, such as an FBI that does a security background check. Sometimes it also includes and it's directed to a copy of the lawsuit is, of course, directed to the Department of Justice so that the government attorneys can review it. There is, in the state of Illinois, at least, in the Seventh Circuit, where I had experience working with mandamus actions, there was a certain person designated to work with the USCIS regarding the mandamus actions that were brought in regards to certain petitions or applications that were pending with the USCIS, and that person could get in touch with the USCIS, and even before the final hearing or even a preliminary hearing, this person could help push that application or petition. So mandamus action requires skills. It's usually done by people who can go to courts and argue on behalf of you in courts. So make sure that you find the right attorney to do that. It's an action that involves paying certain government fees. It can be lengthy, so please be prepared for waiting for a certain period of time. And it's a federal court, so it's very serious. Please make sure you select your attorney thoroughly. Another question, What do I need to travel to the United States just to spend holidays here? Do I need a proof of COVID recovery? Do I need a PCR test? Okay, so everyone who's older than 2 years old must be tested for COVID-19. There are exceptions. So one exception is if you are if a person traveling is under 2 years old, as I said, and if a person can show a proof of COVID-19 recovery within 90 days. That's when you don't have to get tested. Otherwise, you have to get tested. There was a question, what kind of tests are acceptable? I personally traveled to the United States on December 29th. I did an antigen test. I was offered a PCR test that was more expensive, and my antigen test was covered by insurance, so I did that, and it worked out. So that was great. No COVID. So tests are listed on the CDC website. The USCIS is referring to the CDC in terms of the testing requirements and vaccination requirements. So please always consult with the CDC at the time of your travel. At this time, rapid antigen tests are accepted. Viral antigen tests, PCR tests are accepted, but they have to be done within 24 hours before you travel to the United States. There is also a vaccination requirement for all non-immigrants. US citizens, lawful permanent residents with green cards, or people having immigrant visas don't have to present proof of their vaccination, but others, non-immigrants, they have to, unless they are on diplomatic, some official foreign government travel. If they are under 18, then they don't need to be vaccinated. Those who can't be vaccinated due to medical conditions are also exempt. And there are certain other categories that may be accepted from this vaccination requirement. So please consult with the CDC on that. Separately wanted to mention that on January 3rd, the city of Chicago started requiring proof of vaccination for entering restaurants, fitness centers, and places like that. I know that in New York, they have same rules or similar rules. So getting vaccinated is probably that option that can help you travel to the United States and enjoy your stay here. Okay, there was a question about the Build Back Better plan, if it had any implications regarding immigration. So I think I answered this question. There is a question about changing status. I'm a J1 intern. I want to transition to H1B or O1 status. Is it possible? This is a very case-specific question. So to review the circumstances of the case, to actually look at your documents, I would suggest that you consult with an attorney. Generally, I can speak generally about whether it's possible to change status from J1 visa to H1B or O1 within the United States. Yes, it's maybe possible to change status in the United States. One thing I would recommend to, specifically in this case, in this J1 visa holder case, is to check if there is a 2-year foreign residency requirement. If there is such a requirement, it needs to be waived, or a person has to go back to the country of residence and spend there 2 years before coming back to the United States. There are certain grounds to waive this requirement, even if you are staying in the United States. A certain waiver has to be submitted. You can talk to your attorney about that if that's the case for you. H1 specialty, so H1B visa is a very employer-driven process. A person who wants to obtain an H1B visa status has to have an employer who will petition for that person. There are requirements to education and work experience. So it has to be discussed with an attorney. O1 visa is for individuals with extraordinary ability or achievements in business, education, sciences, art, motion picture, athletics, or television industry. So that also something that can be considered, and a lot of people don't even know how extraordinary they are. So if you want to discuss how extraordinary you are and have an attorney go through your documents, evidence that you may have on file, feel free to do so. We have amazing attorneys that deal with these kinds of visas here at McEntee. We'll be happy to help you. All right, let me see if there is a question that I missed. Okay, there is a question if there is the average time for waiting for initial feedback from USCIS after submitting an I-130 visa. Are there still delays in the background checks? Yes, there are still delays. I'm not sure if those delays are necessarily related to the background checks. They're mostly related to the pandemic and backlogs. If there is a background check issues, this is something that may also delay the adjudication of the case. If there are certain criminal convictions or even just simple arrests, or some complications in the immigration history that would relate to the background check delays, then average time. So it's possible to check the processing times for a certain petition filed with the USCIS, such as the I-130 petition. I know that those petitions usually take about 8 months to be adjudicated, but sometimes they're pending for a year, 2 years. It really depends on the case. The processing times is something that you may refer to just to understand how much time the USCIS may spend adjudicating the decision. But from my experience, it usually takes about 8 months. Okay. All right. So I think I covered all the questions and all the news that I think were interesting, relevant, worth of discussion. So thank you so much, everyone. I enjoyed this time. I'm very happy to see all of you joining me here for this live session. And next first Friday will be in February. So you will meet my amazing colleague, Catherine. She has experience working with work visas, with family immigration. She is an awesome attorney. So please feel free to join us next month. I was very happy to be here with you this morning. Enjoy your day and enjoy your holidays. Bye.